Hello, everyone. Welcome to one of the very few second First Wednesdays, um, because the first Wednesday was on a holiday this year. This is IEP 101 Basics for Small Businesses. I'm Melissa from the Business Insight Center at the Central Library of Rochester and Monroe County. Thank you all for joining us today. Remember to mute your microphones and any questions you have, please enter them into the chat. We will be answering them at the end of the presentation. This presentation is being recorded and will be uploaded to YouTube. And if you've registered for the event, you'll receive an email with the link as well as the presentation slides. And I would now like to introduce you to Fatin from the SBDC.
Right. Hi, everyone. Good morning. Thank you for joining us today. Once again, my name is Fatin, and I'm a business advisor with the SUNY Brockport Small Business Development Center, also known as the SBDC. Our center provides free and confidential business counseling to startups, entrepreneurs, and small business owners. Our free services are made possible by funding from the U.S. Small Business Administration, the SBA, the State of New York, and our host campus, SUNY Brockport. Our business advisors are easily accessible in person, virtually, or by phone. Along with our advisement, we offer a fast track to business ownership class. The next class for that will take place in February, and you can register online at www.sbdcbrockport.org. Our website also allows you to make an appointment to sign up for an advisement session with one of our advisors by clicking the schedule appointment link. And also, please make sure to follow us on Instagram, LinkedIn, Twitter, and Facebook. So today, I'd like to introduce you to Dave Bissett. He's the president of Bissett IP Strategies. Dave has been a patent agent registered to practice before the U.S. Patent and Trademark Office since 2004 and has experience in optics, acoustics, mechanical, business method, computer, chemical, biochemical, utility patents, and design patenting. Dave has experience with a wide range of services, practicing before the U.S. Patent and Trademark Office, including filling provisional patent applications, non-provisional patent applications, patent cooperation treaty applications, assignment agreements, patent issuance fees, and successful patent prosecutions. With that being said, I'd like to pass the torch to Dave, and thank you so much today.
Uh, Thank you very much for that, Fatin and Melissa. Welcome, everyone. Today we'll be going over IP 101, go through some basics of intellectual property for small businesses. The disclaimer, the stuff that we're going to be talking about today, we're giving you general information. There's something about your own particular situation that might make what we say today not quite absolutely perfectly appropriate for your situation. So it's not individualized to your particular situation. Covering everything as well as we can in the time allotted. Pretty much any one of these subjects could probably be a full day course themselves, but we're going to go through and try to cover as much as we can. And because there is a lot to cover, we've asked that the questions be held off till the end. Thank you very much for that, and thank you very much for coming to hear the talk. Overview of what we'll be going through today is we'll give you an overview of intellectual property, what the primary tools are. There's four main ones that we'll go over. And after we've told you a little bit about what they are and how to use them, we'll go over some good practice do's and don'ts for each of them. Because there are things that you can do that can help make it a little easier for you to get, say, a trademark issued or a patent issued. There's also some things that you can do that can pretty much make it impossible to get a patent or a trademark of these others. And so we'll cover some of the key aspects of those as well. Go over the good practice do's, do this. Go over the good practice don'ts, don't do that. The first thing that we'll cover is what the tools are that are available. We'll talk about trademarks and service marks, um, which help you protect your brand. We'll also talk about copyrights, which protect expressive works of authorship. We'll talk about the trade secret, where you try to keep everything that you're doing confidential, try not to let people know anything at all about how you're doing what you're doing, the details of how you make it. And we'll also then talk about the patent, which is pretty much 180 degrees opposite of the trade secret, where you tell the world how you make and how you use what you do. And in return for that, the government gives you a limited monopoly, usually for about 20 years. The first that we'll talk about today is the trademark and the service mark. Trademark and service marks protect words, phrases, symbols, or designs used in identifying the source of the goods or services. In effect, they protect your brand. They protect all the different peripherals that you use there in protecting your brand. They identify a product or a company without obviously describing that particular entity. In the world of fast food hamburgers, people know what a Whopper is. It's that really large, thin beef patty with some lettuce, tomato, maybe onions, condiments on a really large bun. Comes from Burger King. When you see the term Whopper, you pretty much know what you're getting and where you're getting it from. Likewise, the Big Mac from McDonald's, you know that there's going to be 3 slices of bread, a couple of small patties, all the rest of the stuff that goes with that. It helps through their marketing. People know what they're getting and where they're getting it from. A company name isn't registerable by itself, but if it functions as a trademark, it would be registerable. Like John Deere Incorporated does not trademark John Deere Incorporated, but the term John Deere they use as a trademark, and so they do have the trademark on that. In order to use a trademark, you don't have to have it registered with the U.S. Patent and Trademark Office or with the individual state you're in's Department of State, but you will gain additional protections, and it becomes more readily enforceable if you do register it. And the way to do it at the USPTO is you can go to www.uspto.gov, find out a lot more information about it, and that's where, if you have an attorney helping you do that, that's where they would go to do this. And by the way, I'm a patent agent. I specialize in helping people get patents on their inventions. I am not an attorney, so I don't do trademarks. But I have a pretty decent background in IP, so just kind of covering all the stuff here today. If you do register your trademark, it's going to be valid for 10 years, and you can keep renewing it every 10 years for as long as you continue to use that trademark. There are trademarks in the US that go back to the 1800s. The very first trademark was done here in 1870, and there's a brand of rope and cord, Samson, that's still in use as of at least a couple of years ago when I last checked. That dates back to May of 1884. So you can keep your trademark going for a really long time. It'll outlive you if you so you and your heirs so want it. Why do you want to get a trademark? Well, the trademark helps you protect your brand. It helps you keep other people from trying to usurp what you're doing. Taylor Vineyards famously kept a gentleman whose last name is Taylor from being able to market his wines as Taylor Wines. He ended up instead starting the Bully Farm vineyards, or Bully Hill vineyards. Sorry. So that it's how you protect your brand. It's how you keep others from using your product's names, from using your slogans, your logos. You don't want people using a logo that looks really, really similar to yours if they're selling the same thing that you are. You want customers to be able to know what you're doing. And by having the different brands all kind of distinct and unique, it minimizes consumer confusion. What's in it for the registrar, whether it be for the people here in New York, the New York State Department of State, or for the trademark office. We got people down in Florida. You would go to the Florida Department of State. Well, consumers have clarity about who they're buying from. Somebody shows up at your work with a whole bunch of Big Macs, you know that they came from McDonald's. And again, it's done to minimize consumer confusion, letting everybody know where what they're getting comes from. How do you go about getting a trademark if you wanted to go and get one from the trademark office? Well, first you come up with the idea of what you want for your trademark or your service mark. And trademarks are used for goods or when you're selling goods and services. A service mark is when you're just doing services. And there's a few other different things like collective marks and that are forms of trademarks that we're not really going to go into today on that. But get your trademark, figure out what you want to do, or your logo, your tagline, what it is that you want to protect. You can have it in use before you apply for the trademark, or you can apply for it when you plan to get the trademark into use. So you can find out before you actually start using it if the trademark office will let you use that trademark if you can get it certified there. It's recommended to do a search before you file for the trademark. Make sure that what you're doing is going to be not already out there. You can use the search system with the trademark office. Also here in Rochester, we have a great resource, up on the third floor of the Carlson Library there. We have a patent trademark resource center, which has all of the same tools that they have down in Alexandria that are there available in Rochester.
Fourth floor.
Yeah.
We're on the fourth floor now.
I'm sorry. I always get that confused which one you're on. Sorry. But yeah, the librarians there are very helpful. You can also pay somebody to do a search for you. After you think that what you want to protect is trademarkable, you would file your application with the USPTO. There are 34 different classes of goods that you can protect. There's 11 different classes of services, and you may need to get a trademark for more than just one class. Like, let's say that you are making wine, and so you got your winery, and you also want to sell wines at your restaurant. Maybe you've got T-shirts and caps with your logo on it or your tagline. Each of those would be under a different classification, and you'd want to get a trademark on each of those. If you do decide to file for a trademark, you do it electronically. And once you file, the trademark office will review your application, decide if what you've got is trademarkable or not. Go through what they call the prosecution. Basically, they look at it, review it, come back, tell you if they think that you can get the trademark or not. If they say no at first, maybe you can make some changes to it. Eventually get to a point where hopefully it is allowed, and then you would have the opportunity to renew it every 10 years as long as you're still actively using that trademark. Like I said, oh, I'm sorry. Yes, the TES is the Trademark Electronics Search System. That's the search system that the trademark office has. And the PTRC is the Patent Trademark Resource Center, of which the library there in Rochester is one of. Hopefully that answers the question on that. You're very welcome. So that's kind of the quick overview of the trademarks. And when you're using the trademark, before you have it registered, you can put the TM after it if it's a trademark, put the SM after it, and that shows that you are considering what you are using there as your logo or your tagline or your brand name to show that you're considering that to be your trademark. It's helping to point out that you are treating it that way. And it's really good practice to do that. The next up, we'll be talking about copyrights. Copyright protects literary works, musical works, dramatic works, movies, records, dances, art, and even architectural works. For those of you there in Rochester, the Signature Bridge over the Genesee on 490, I don't know for certain that it's been copyrighted, but I would be surprised if it wasn't. It's got a very unique look to it, and so even that can be copyrighted. Basically, any expressive work of authorship is something that can be copyrighted. People may not realize this, but copyright is automatic. As soon as it's in a recordable form, as soon as you've put your words to paper, you have copyright. As soon as your photographs hit the screen, they're copyrightable. Like for dances, you've got to go through a special calligraphy that identifies all the steps in that. But once it's there, the copyright's automatic. But if you apply for the copyright with the Library of Congress, the trademark office, which is a part of the Library of Congress, then you can get additional protections, and it becomes easier to defend what you have. And that's similar to the trademarks before. If you actually register the trademark, it becomes easier to maintain the protection. Since 1978, you can get copyright protection for up to 70 years after the author's death. So you have a toddler, 1-year-old. She does a little song and dance for you. It's all her own creation. Say she lives to be 101 years old. You recorded it when she was 1. It's protected for the 100 years of her life and then another 70 years thereafter. So you can have a copyright for a really, really long time. If The works are created anonymously or under a pseudonym, or if they're done as a work for hire, you pay somebody to write a jingle for you. Those would receive 95 years of protection from the publication date, or if for some reason they weren't put out on the public for the first up to 25 years of it having been written or put out there, you'd have 120 years of protection. So copyright is something that you can have the protection for a very long time. How do you go about getting a copyright with the Library of Congress? Well, the hard part is you develop your unique expressive work. You come up with something creative. After that, you can go to www.copyright.gov, which is the Copyright's website, the Copyright Office's website. They've got forms there for if you're trying to do a single book or a magazine article, or if you're trying to do a serial or a song or something like that. Choose the proper form to fill it out. Submit a copy of your work with it, and pay a fee. If you're just doing a single article, it's going to be about $45, and that's it. That's all you have to do to get the copyright. And a lot of people will self-copyright things with the Copyright Office themselves. If you're not comfortable with it, you can talk to a business lawyer. They can do it for usually fairly inexpensively to help you out. We're also going to talk about the trade secret. With the trade secret, your company or an individual is going to keep information secret from their competitors, their customers, and the general public. You need to be actively protecting the trade secret in order to get protection from somebody stealing the trade secret from you. So you'll want to be using non-disclosure agreements with the people working for you, with your suppliers, to make sure that they aren't saying what they know about what you're doing. And the big key to a trade secret is it provides less protection than you would get if you wanted to patent your invention. And the big key to that is if somebody on their own comes up with what you're doing, if they figure out what your secret ingredient is on their own, then there's really nothing that you can do to stop them from using it, because you were just trying to hide it. You didn't have a patent or something else like that. But whereas a patent will run out after 20 years, a trade secret can give you protection for much significantly longer than that. The formula for Coca-Cola, although it's gone through a few different changes, doesn't have cocaine in it anymore, doesn't have cane sugar in most of their versions of it, but it's still essentially the same formula it's been since the early 1900s. We'll also give you a little info on the patents. What's a patent? Well, a patent is an item that allows an intangible item, your idea, to have a tangible transferable value. It provides the owner of the invention with the right to exclude others from making, using, or selling the invention. Note that we say that it gives you the right to exclude others. It does not necessarily give you the right to make or use or sell your invention. And when we get onto the next slide, we'll explain why that is. It gives the inventor a limited monopoly on the invention. That monopoly to keep others from making and using your invention. For most patents, 20 years from when you file an application. For the design patents, it would be 15 years from when the patent issues. And the forefathers of this country found them to be so important that they actually provide for patents in the Constitution. Copyrights are also provided for in the Constitution. And I quote, Article 1, Section 8, Clause 8, securing for limited times to authors and inventors the exclusive rights to their respective writings and discoveries. Again, you have a constitutional right to get a patent on your invention. You also have a constitutional right to have your works of authorship protected, which is kind of cool, I think. What is patentable? Any process, machine, manufacture, or composition of matter, or an improvement thereof. So, we talked about how you won't necessarily be able to make your invention because there's a couple of ways. One, if you do an improvement over something else that's out there, someone might have a patent on red widgets, and you come up with a specialized red widget that's better than the general red widget, you have a maroon widget. Well, if somebody has a patent on that entire class of red widgets, that maroon widget might still fall under the red widget patent. So you might not be able to make your maroon widget without the permission of the red widget holder. Of course, that person wouldn't be able to make your maroon widget without your permission. Also, and this is a more common way that you wouldn't be able to, somebody has the patent on the red widget and it's made by process A and process B. You come up with a way of making that red widget that's a lot more efficient. Process C, nobody's ever thought of it. Nobody's ever seen it or done it. Well, you can use your, the process, you can keep others from using that process, but because you're making the red widget, which is already patented, you can't necessarily do that without being licensed from the owner of the red widget patent. But with that said, that process, machine, manufacture, composition of matter, or improvement thereof needs to be new. It needs to be novel. It needs to be unique. It needs to be actually inventive. If something is already out there, and if it's out there anywhere in the world, it's not inventive, and you won't be able to get a patent on it. It needs to be useful. That means useful to society, not necessarily useful to the owner of the patent or the inventor of the patent. Which is a very low bar to cross. Somebody can come up with a really great way of breaking into a home or a store or something. You get in, get out, you do no damage to the lock whatsoever. People don't even realize that you've got an in. If you tried to get a patent on that, stating it in that way, you probably are not going to be able to get that patented. The patent office will say, yeah, ways to steal from people, that's not useful. No, you can't get a patent on that. However, that same method of getting into the doors, maybe you could use that because there's somebody is trapped in a fire on the other side of the door, or somebody's fallen and they can't get up, or there's a little child that's there and they don't know what they're trying to do. Well, you can get in, you don't do any damage to the door, you save that person. Now that is useful. So the way how it's presented, that, like I said, that's a really low bar. And the last part is it needs to be non-obvious to somebody that is proficient in that field. don't have to be the most skilled person in it. If an absolute genius in the field, it wouldn't be obvious to them. That doesn't preclude you from getting the invention. But if for the average person in that particular field would know how to make and use what you're doing, then you wouldn't be able to get a patent on the invention. So if red widgets are out there, going back to our widget example, if red widgets are out there and blue widgets are out there, and if you would combine them, you'd get a purple widget, which has properties similar to the red and the blue. And everybody in widgetry knows how you would do that, even though nobody's ever done it before because nobody ever had a need for a purple widget. You wouldn't be able to get a patent on your purple widget because it's obvious. Now, if you took a red widget and a blue widget and you ended up with a green widget, which has properties completely distinct from what the purple widget's what the purple widget's properties are, you very likely would be able to get a patent on that because it's not obvious that something that's blue and red would end up making something that's green that has different properties. So that's kind of what we mean by non-obvious. Who can obtain a patent? Well, the inventor or the assignee of the inventor, someone that they assign their rights to in writing, is eligible to receive a patent for the invention. They would be the applicant. You include all inventors on the patent application. And if one person, let's say there's 20 claims on the patent, one person was involved in all 20, another person helped them with the 20th claim, well, that second inventor is included there on the application that the first inventor came up with. And they're each considered 100% owners of that invention. Yes, it's a little weird, but yes, all the inventors are 100% owners of the invention. So, boy, all inventors get included for something like that, where one person did 19 of the claims and the other one was just the one person was only involved on the second. You might want to do that as two separate patents so that they each share the ownership of the one, or they could work out an assignment up front amongst themselves, and we'll talk about that more in the do's and don'ts. Also, non-inventors are not included. If you didn't do anything inventive, you don't get included on there. If somebody wants their husband or their wife to be an owner of the invention, you don't put them on as an inventor if they didn't do anything to help with that. You would put them on, you would set up an assignment agreement, assign the rights to either a different entity or to that person, and that's how you give them the additional ownership. And again, that's because the inventor is 100% owner of the invention. Who gets a patent? In most of the rest of the world, the first to file for an invention will get the invention will get credit for being the inventor. Here in the U.S., a little over 10 years ago, we switched to a very similar system. First person to get an application into the patent office will be the one who is deemed to be the inventor. So you might come up with an idea, take you 10 years to get it to the point where you're ready to get an application into the system. Somebody else comes up with the idea a month before you get it into the system. They get it in the day before you do. They're the inventor. So you want to be quick with whatever you do in trying to get this submitted. Steps to obtain a patent from the USPTO. The inventor conceives of the invention. They have the eureka moment. That light bulb over their head goes off. Like, cool. That's really the hard part, coming up with the idea. And the other real hard part is you work diligently to perfect the invention. you get to a point where you can actually make it and use it. That's said to be reducing the invention to practice. There's two different ways that you can do this. You can actually reduce it to practice, ARTP, which means that you have actually made it. This pen, if I had invented it, I've actually made it now so somebody can use it, they can hold it, they can see how it works. That's one way. You also can constructively reduce to practice your invention, CRTP. And by doing that, you put down on paper in enough detail for somebody to make and use the invention without having to do any undue experimentation. And again, we're talking people that are proficient in the field. Doesn't have to be to the general layperson. If you constructively reduce your invention to practice so that somebody else can make it and use it, then you are said to have reduced it to practice and you have the invention. And oddly enough, if you have a patent application, again, ARTP actually reduced to practice, CRTP constructively reduced to practice. If you get to that point, which a patent application that ends up being determined to be eligible to have a allowable invention is constructively reducing your invention to practice. So the patent application, if you get that, you have reduced it to practice. It's recommended that you do a patentability search. Not everybody needs to do that. So I've had clients who are truly experts in a very narrow field and they know exactly what is out there and what isn't. And they know for a fact that what they are coming up with is not out there already. So they don't bother with the patent search. For many people, patent search is advisable because a lot of things can be very crowded fields and it's a long and costly process to go through trying to get a patent. And if somebody else already has invented what you do or something very, very similar to what you do, you either aren't going to be able to get a patent, or if you do, you're going to get something that's so narrow in scope that there isn't much value to it. And again, the people at the library, Melissa there can help you with that. There's also professionals that do patent searches that you can pay to have a search done. Continue on. Once you've got your invention reduced to practice, file a patent application. Again, you want to do that as quickly as possible. Why? Because the first person into the system is the person that's going to be considered to be the inventor. You then do what they call prosecute the application. A patent examiner, and what we mean by prosecute is patent examiner will review your application and determine whether they believe that what you're doing is eligible for a patent or not. And they'll send you back in what's called an office action. And in it, it'll say, yep, I think that all your claims are allowable. You're great. Or what more likely will happen, probably about 95% of the time, the patent examiner is going to come back and say, well, no, I don't believe that you can get a patent on this because I think that you read on what somebody else has done, or somebody else's invention. If you combine this other thing with it, it makes what you've done obvious. After you feel very sad, very frustrated, and go, oh my gosh, I've just spent years and I spent so many dollars. It's I've done all this and they're telling me I can't get a patent. But wait, what they say I read on, I don't really read on, because what that other thing does, it can't do what mine does. or the way how these two references interact with each other, they wouldn't work. Or maybe you might say, yeah, I agree that the way my claims are written, yeah, they're a little too broad. That is kind of covered in what I wrote. I can change my claims around, narrow them down, and now we're good to go. So the prosecution continues. I might go back and forth 2, 3, maybe even more times. And eventually you get to a point where a patent will either issue or it doesn't. In theory, it's a 3-year process, but expect this to take probably more like 3 to 4 years. Again, it's a long, drawn-out process. And then after you get to a point where your patent is allowed, you pay issue fees. There's a review period where somebody can claim that you derived your invention from them. And then after that, 3.5 years after your patent issues, 7.5 years after your patent issues, and 11.5 years after, you pay a maintenance fee, which goes up each time to keep the patent active. And so that's pretty much the overview of each of those different IPs. I'd like to go through some good practice do's and don'ts for each of them. For trademarks, use the TM, or if you got a service, I provide a service to people, so I use a SM there with my my logo. You can see there. With your logo, your tagline, your brand, and always use it, even when you're having internal correspondence with your business partners and your employees. Use that TM. You need to show that you are protecting that to make sure that somebody else doesn't come along and say, well, you were treating it just as a random verb. You weren't treating it as your own property. Make sure when you do file an application, make sure you've got the proper class. You want to protect your the wine that you were making. Make sure that you file under the winemaking distilling category. Don't file under the restaurant if that's not what you're trying to protect. If you go for the wrong class, you won't be getting the protection on what you're actually doing. Decide whether you're doing business in one state or multiple states before filing. It's cheaper and a little easier to file and get the trademark approved if you're just in a single state. But if you're in multiple states, and now that so much business is done on the internet, almost everybody is doing business in more than one state, you would end up going to the trademark office, the USPTO, rather than doing it with the Secretary of State within your state, and then file to the appropriate location. It's recommended you to perform a search before filing because though this isn't as long a process as patenting, this is more of like a 6 to 18 month process typically. So it's good to do a search there. For trademark, some don'ts. Don't try to trademark items more complex or complete than a tagline or a logo. You're not going to be able to get a trademark on an entire paragraph's worth of material. You are going to be able to get a trademark on something short like I'm loving it, or nothing runs like a deer, or that particular class of goods or services that you're working with. Don't try to trademark descriptive expressions. Pat Riley famously back in the 90s coined the term three-peat when his Lakers were trying to win a third NBA championship, and that was a unique word, so he got a trademark on it. If you try to trademark a a word that's already out there being used in general, you're not going to be able to get the trademark on it because the trademark office doesn't want to be taking commonly used words out of the lexicon. That's why things like Xerox, the name Xerox came up. It's a totally unique. It wasn't there before. It's something that they got the trademark on. Some good practice dues for the copyright. Do use the copyright nomenclature on expressive works you have created or have paid to have created for you. And by the copyright nomenclature, what I mean is use that circle C, the year, and then your name or your company, that whoever you want to be holding the copyright. When you do that, you get more protection than just having uttered these or just put them to paper. You can still protect them even if you haven't done this, but it becomes easier when you do it. And it becomes even more easy and you get more benefits if you actually go through the process to have your material copyrighted. If you copyright what you've put down within 3 months of having come up with it, then you can hold on here. Within 3 months, you can actually file for damages for people trying to go after what you've done. If you file within 5 years, you have a presumption of having been the original author there. So the quicker you do this, the more benefits you have. Some good practice don'ts within the copyright. Don't delay when filing for a copyright. Again, you have more protection and better protection the sooner you do it. And if somebody else copyrights something, then you have to try to go through and show that you came up with it before that person did. And it's a lot harder to do that than to come through the other way. Don't try to copyright something that you did not come up with. That's stealing. Don't do it. Some good practice dues for the trade secrets. Use NDAs, non-disclosure agreements. That's what the NDA stands for, non-disclosure agreement. You also want to be using, if you can, non-competes with your employees, realizing that those will have expirations. You can't have a non-compete agreement with somebody that runs indefinitely because you have to let them at some point find employment. You want to keep stuff secret when and where possible. Don't let anybody know what you're doing if you can help it. And ideally, if you are, say, manufacturing something, say you're baking a cake, have some of the ingredients mixed by one group of your employees, have a different batch mixed up by other employees. Don't let everybody see the entire recipe. Have somebody else actually doing the baking of those subcomponents when it's possible. Some good practice don'ts with the trade secret. Don't forget to be ever vigilant. If you just leave your formula sitting out on your desk and some visitors are in, they see it, they didn't actively go and try to find it out. It was right there. You left it sitting there in the library. Somebody picks it up. They didn't do anything on their own to go out of their way to try to steal that from you. You won't be able to protect it. With patenting, some good practice dues. After you've got the invention, work diligently to protect it and reduce it to practice. Speed is your friend. Again, the first person to patent or to file a patent application is the one that is going to be deemed to be the inventor. So speed is your friend. Develop a strategy. Understand what it is that you're really trying to do with getting a patent. Are you trying to set up so that you can make what it is that you do? Are you trying to keep other people from doing it? Are you looking to be able to license? Are you looking to sell? Depending on just what it is that you want to do might affect the way how you draft up your patent and get an enabled application into the system. Enabled is a little bit of a patentese, which means you've told somebody how to make and use your invention without undue experimentation. It's a fancy word. If you're talking to a patent agent or a patent attorney, they're going to use it a lot because if something's enabled, then it'll get you a priority date. It'll get you ahead of anybody else that tries to file later than you. A non-provisional application, which is what is typically thought of as a patent application. There's also something here in the US called a provisional application. A provisional application isn't as formal as a non-provisional application. It might not even include any claims. It's good practice to include them, might not. The background of why you're doing what you're doing might not be as explicitly spelled out, but provided in there you've told people how to make and use your invention, you can you'll get your priority date, and within 1 year you can file a non-provisional application, which is a little more detailed, a little more formal, and instead of getting 20 years of protection from the filing date of that non-provisional application, you get 21 years of protection because you had the 1 year of protection from the provisional, and it goes out. So you gain an extra year of life. You also gain an extra 12 months to figure out if you really want to get the patent or not. If you don't think you're going to be able to monetize your invention, maybe you don't want to get a patent. And if you're thinking about going internationally, you've got a 12-month window from your filing date to get something into the rest of the world. Whatever country you want to be in, you have to have an application there. There is a thing called a PCT application, Patent Cooperation Treaty, which is really helpful to the small inventor, the small company, because if you get a PCT application put in within 12 months, you gain an extra 18 months to get your application into any other country in the world. For most everywhere, it's an additional 18 months. There's a couple that it's a little different, but all the ones that people typically care about from here in the US are covered that way. Because if you say want to get a patent protection in Japan, well, you got 12 months to get a application put into Japanese, and not just Japanese, but it has to be Japanese patentese. Make sure that it's meeting the requirements to be enabled there in Japan. And that 12-month period can go by really quickly, and you're trying to figure out where I might be making this, where I might be trying to sell this, and the PCT gets you an extra 18 months, which can be really, really valuable. Some more good practice do's on patenting. Include as many novel operational variants as you can enable. The different materials, different valid process ranges, etc. for that. Because again, somebody else, if they come up with something a little different, they come up with an improvement over what you had, they might be able to keep you from being able to make your invention via the better process. And the more materials, more process ranges you put into there, the broader your coverage can be, and you can keep people from doing more things. There's more valuable to your patent. Include broad claims and narrow claims. The broader they are, the more values there. They might be too broad, so you might refer back down to the narrower ones. And all that kind of comes about during that prosecution phase of the application. Keep things quiet. Don't let people know what you're doing, even though it's now first to file, not first to invent. Tell people you got an idea for doing something, even though you haven't told them exactly what it is that you're doing. They might come up with their own way of doing that thing, and maybe they get it into the patent office before you do. So, and when possible, use non-disclosure agreements with your employees, with people that are supplying for you. Also, get assignment agreements in place with people. Again, all the inventors are 100% owners of the invention. So you want to have assignment agreements worked out with your co-inventors. You also want to have assignment agreements worked out with the tradespeople that are working under your instruction. If all they're doing is, figuring out where to put rivets in something, you don't have to know where the rivets go. The tradesperson can know where that goes. It's nothing inventive. They aren't inventors. But maybe instead of rivets, maybe they come up with a totally different material that makes the invention much better than the materials you were thinking of using. Or maybe they come up with a way of connecting some pieces together that makes it much more efficient. Okay, now they've just invented something, a part of this. They're now 100% inventor. If you had an assignment agreement in place with them before they started doing the work on this, then even though they're the inventor, you own their rights to the invention. I think this is the last page of good practice dues on patent. Keep good records. And it's no longer first to invent, but if you want to try to prove that somebody else derived your invention from you, or you want to keep somebody else from trying to say that you derived it from them, having the records that you were working on this 2 years before you ever even met this person could be helpful in proving that it was in fact your invention. And some additional items that may be useful. Submit additional applications as new embodiments are developed. Again, a patent application has 20 years of life. You come up with some new improvement over what you had, say 4 years into the process, put an application in for that. Now from your original version, you might have 24 years of protection instead of just the 20 years of protection. And you'll have the better version of this protected, and somebody else won't be able to come along and do the better version on you. And remember that provisional applications can give you a year to help you determine if you're going to be able to monetize your invention. Also, one thing I didn't mention is that as soon as you have an application in the USPTO system, you are said to be patent pending. That's all the patent pending means. It means that an application is live and it hasn't issued as a patent yet, and it hasn't been abandoned. So as soon as you have an application in the system, you can start saying that you are patent pending. And if you see somebody else's patent pending, it just means that they're trying to get a patent. Don't put your invention in public or on sale before you have an application in the system. Because if you have it out there in public, in most countries, you have an immediate bar to patenting. You've considered to have given it to the public. You've put it into the public domain. Most countries won't give you a patent if it's already out there in the public at all. Here in the US, you have a 1-year window from when you're in public or on sale before that bar comes. But again, if it's out there in the public, somebody else might come up with a better idea of how to do what you're doing, and maybe they get that better idea into the system before you. So try to have an application in the system before you get it out there. Unless, now, if you don't have any intention at all of patenting your invention for whatever reason, the cost, the time, for whatever reason, you just don't want to do it, then don't, that you're not going to do it. Then you do want to get it out there in the public, because again, once it's out there, nobody else can patent it around the rest of the world. There's a nearby. And if you can show that you were using your invention for a full year, then before they did it, then you can actually petition to be allowed to continue to use your process. You can't give other people the right to use your process unless you 100% give them that, but you can continue to use your process if you can show that you were doing it at least a year ahead. So in that rare situation where you don't want to patent your invention, get it out there in public right away. And now I will take questions, and thank you very much for listening. I know we covered an awful lot.
Okay, we have a
Dave,
few
there's a
questions.
couple of questions on the chat, if you could address them.
Okay, sure. Let's see.
I've been copying and pasting them. I'll read them out for you.
Okay.
Okay, first question. If I have an invention that requires a third party to create a 3D printing file for me so I can 3D print a prototype, is the third party a part of the invention? Do they have a claim to my invention?
It depends. If all they're doing is just printing it out for you, I mean, you developed it all, you gave them all the idea, the simple act of using a 3D printer and putting the part out there, that wouldn't be considered inventive for the most part, but maybe they made some significant change to what it was that you wanted them to do, and that significant change makes it better than this improved version of the invention they probably did. And again, we mentioned that you want to have an assignment agreement with the person. A lot of model shops will sign assignment agreements with you that, yep, I agree that if I do something inventive here that makes your idea better, I'll give you the rights to it because I wouldn't have come up with it anyhow on my own, entirely on my own. And I don't want to be in that business of trying to sell what it is that you were coming up with. My business is making the models. So like I said, it depends on if there's something that's truly inventive there or not. But if you have an assignment agreement in place, then you don't have to worry about whether they invented something or not. Odds are they didn't, but it's possible. A few others, right?
What about software improving on processes? For example, yellow taxi cab service versus Uber. Would Uber patent?
Uber as a business method, I would be surprised if Uber doesn't have some form of patents to what they're doing.
They have lots of patents, but they're
Yeah.
all software based,
Okay.
or the majority are.
Yeah, which is kind of what I'd expect. So yeah, so if you do something that improves over the methods that Uber is using, you likely could get a patent on it. But it obviously Uber does have patents. There are lots of software patents out there, and software is a really interesting area of IP because as court cases come through, just what is considered patentable and what is not considered patentable within software will change some. Right now, pretty much you need to have the software operate on a particular machine or system and have cause some sort of a transformation to what it is that's being dealt with. And that all can get very, very gray. I have some software related business method patents through the years, and Yeah, there's definitely a bit of an art to getting those approved. Hopefully that answered the question.
Returning to the 3D printing question. Um, the question was regarding the fact that I do not know how to create the 3D file. I can't create the file, so I hired a third party to just create the file, not about printing, not improving, just creating the file for me. Do they have a claim to my invention because I needed them to make the electronic file?
They likely don't, and it would depend on the exact specifics of what happened, but for the most part, that would most likely be looked at just as a tradesperson did a task for you. You told them what the part is that you want, how it should be shaped, how it needs to function, how it needs to the sizing, the dimension. You told them pretty much what it needs to be. So odds are, no, they didn't invent something, but it's possible that they did. And again, get an assignment agreement with this person or this organization that you're dealing with, and then you don't have to worry about did they or didn't they. Um, and if they won't sign the assignment agreement, then you've got to decide: do I continue to want to work with them or not?
One thing we recommend normally when creating logos, but if you're hiring someone to get a work for hire contract, that also transfers the IP. Okay. Going into trademark a little bit. I
Okay.
found out that the name of my cleaning business also exists in Mexico, and they have a registered service trademark symbol on their name. How would this affect me?
Um, that's a really good question. If they're just doing the business in Mexico, it likely doesn't, but that's really a question for a a trademark attorney. Um, I would definitely, in the meantime, while you're using your own trademark, be putting the trademark symbol there on what you're doing, and maybe it might not hurt to ask the people at the library to take a look and just see if they've tried to register the trademark here in the U.S. or if they're just strictly in Mexico.
Yeah, if they haven't registered in the US, then they don't have protection here.
Right.
So that's what we would look. We would see if they ever registered here. Okay. If you start a trademark application and can't finish because your attorney was a shyster, and so the application was abandoned, can you still apply for it later?
I believe that the answer to that would be yes, because trademarks, and again, I am not a trademark attorney, so this is coming as a layman's opinion here on this, but I know that trademarks go out of go out of service and they get resurrected later on. So my gut feel is that yes, you would be able to reapply for it, provided somebody else isn't using that trademark. If somebody else has come along and basically taken it, then you might need to talk to a lawyer about seeing how you'd go about trying to get it back, or if you even can. But yeah, when products to keep a trademark alive, you need to be actively selling what it is that you're making and doing. And trademarks very often end up getting what the trademark office considers to be dead. And then later on, if that particular product line they want to sell it again or use it again, it can be revived. So I would have to believe, unless you got some really unusual circumstance, that you would be able to get that going again. Um,
We have
See a question?
Oh.
Oh, go ahead.
We have filed domestically, but missed the 1-year deadline to file a foreign application. This may have significant implications in the future licensing of a product. What are some things we may be able to do to strengthen our foreign IP?
Um, the first question I would have for you is, do you have any improvements to that original version that you've applied for, and is it still out of the public eye? If it is, um, you can try to get a patent on that improved version, and then make sure that you get at least the PCT application, or if you know the particular country you want to be in, make sure you get that application into that country within a year. If being able to get into that foreign market is really important to you, you might want to see if you can't. There's no requirement that you wait a full year to when you file here in the U.S. to go into another country. You could file there with that improvement, but that would be your best bet. Or maybe you've got a different process that you can use to make that original thing, an improved process to how you were doing it, and then get a patent on the process, and then try to get that in the other country. So there's a few things that you can do. That's something that you'd really want to talk with an agent like myself or an attorney, see what some of your options are. But in general, those would be a couple of things that might be ways to get around that issue.
Hey, do you recommend going to a lawyer for creating our NDA?
Um, yeah, a lawyer can do that for you, and yeah, any sort of contract, it's always good idea to have a lawyer take a look at it. You can go to like LegalZoom, or you can try to just see from some other things. But as with so much out there in the world, sometimes when you do it yourself, you end up missing something that uh, a pro would have caught right up, and could have set up for you. So yeah, I would say it's never a bad idea to have a lawyer take a look at something like that. It's a little costly, but in the long run, it can save you money.
Okay. When obtaining a trademark for a business and goods, are there any resources to assist in business startups? I could answer this a little bit, because it really depends on what you need as assistance. I don't know anyone that will help you actually do the filing, like, on your behalf for free, unless you get a trademark attorney. But if you're looking for like a trademark prior art search, that's something that we provide here at the library to see if anyone has already trademarked in the class of goods and services that you are looking into, or if you're looking to trademark in other countries, we could also do that search. We're not attorneys, so we can't give you a yes or a no if something's going to be accepted, but we could give you a stack of examples and of the same trademark in the same field, so you could make the informed decision you want to change it. For more complicated issues, we do have a trademark attorney that we could get you a free consultation with.
And if
do you have
you're
anything else, Dave? Sorry.
And I was just going to say, and if it's more like on just the business side of things, the SBDC has some great resources to help with startups, not necessarily in the trademark field, but can help you in general there. SCORE is a helpful resource. I know that the patent office, so probably the trademark office, also does have some pro bono programs for lawyers help, but I don't know what the
Oh,
qualification is
yes.
to be
Syracuse
allowed.
has one.
Yeah.
Sorry.
Yeah, I don't know what income levels or what point in a startup you have to be to qualify for that pro bono service, but there are some that are out there.
And then we have uh, one last question. Could you speak more about the CPC application mentioned?
You see the PCT. Yes,
Okay.
yes, the PCT, Patent Cooperation Treaty application, it is something that's recognized by all of the countries that are part of WIPO, the World Intellectual Property Organization, and you can file it with the USPTO. It is similar to a regular US patent application. The formats of the paper that it's on, everything's filed electronically nowadays, so it's not actually paper, but the sizing of the documents is a little different. The formats for the different sections of what's there is slightly different, but in general, it's the same application that you'd be filing with the USPTO to get protection for here in the US. Um, the PCT application itself is going to add ballpark, and this doesn't include any attorney or agent fees. The PCT application itself is going to cost you about $2,500, $3,000 over, but that money is buying you 18 extra months of figuring out where you want to go. It also will get you you'll also get a search report from the office that you filed with that will give you some ideas on whether they consider what you've got to be patentable or not, give you some ideas of some of the art that's out there. So you already will know some of the things that you need to be kind of watching for when you get to the prosecution phase in whatever country you're in. And again, while that PCT application is an international application, there is no such thing as an international patent. You get patent protection in any given country or, like with the case of Europe, region that you apply to. People, you hear them say like, "Oh, I got an international patent." It's like, no, you might have an international application. You might have individual countries that you've patented in: Australia, Canada, China, India, Japan, Europe as a whole, et cetera, et cetera. But you don't actually just go into um, you, 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 you don't get a patent that covers everywhere in the world. You can have the application that covers everywhere in the world for that 18-month window, but that's kind of it there.
Couple more questions popped in. Many years ago, my patent was assigned to my employer per employment agreement. Later, they did not renew it. What does that imply?
What that implies is that what was included in that patent, now anybody in the world can go and do that, or at least here in the US, assuming that because I don't know if they kept the patent alive in other countries. So if it's alive in other countries, then no, they'd still hold the rights to it. But here in the US, that would be in the public domain. So if you want to make and use the stuff that was covered by that, provided it's not infringing on some other patent that might cover some aspect of that, you can make and use it. It doesn't just imply, it says that they no longer feel that they can make money off of it. Anybody else can try. So that's good for you.
And the last one at the moment. A friend of mine is an artist, and based on my ideas, she created a design, a graphic for clothing I'd like to produce. What kind of agreement do you recommend we have to ensure her IP is covered for the design, but that will still permit me to proceed with production and sales? Any best practices on this?
That you're, again, getting slightly outside of my area of expertise. A business lawyer can definitely help you there, but something like that, very likely you'd want a licensing agreement with this person where where she has presumably a trademark on the graphic, and that you get a license to make the clothes with that graphic. Yeah, but a licensing agreement most likely is what you're looking for. And that can be set up in a lot of different ways. It can be set up with an upfront fee. It can be set up with a royalty per garment. That can get really complex. And like I said, a business lawyer would definitely be able to help you out with the details of that. But likely you'd want to be licensing that.
Looks like it's the last question for today.
Okay.
So
I would like to thank Dave for coming and presenting today. And thank you all for coming to attend the first Wednesday of the year.
Even though it's the second.
Although it's the second. It's the first event.
Also, thank you everyone for attending the session today. And if you have any questions you'd like to reach out to the SBDC, please go to our website and we'll be happy to assist you with any sort of business related advisements that you might require. Thank you so much. And thank you, Dave and Melissa.
You're very welcome. Thank you very much for letting me present. I've got my contact info now there at on the screen, and yeah, I'd be happy to answer questions beyond this if somebody has them. And once again, thank you so much, Fatin and Melissa, for letting me present here.
Thank you.
Okay, and that is the end of our program. Just a reminder that all the slides and the recording of this webinar will be put up on YouTube and also emailed out to all registrants. And I hope to see everyone next month.
Take care. Bye-bye.